ditch. There's no water in the main ditch. So you join a bunch of your other settlers, friends, on the bank of the Cache-la-Poudre River. There's no water in the river. Like any self-respecting settler, you go back to your cabin, your house, you get your gun, and you start walking upriver to see what happened. Well, what happened was that Benjamin Eaton had completed another project in the vicinity of Fort Collins, a new ditch, the Lake Canal, and had diverted the Poudre River. A meeting was organized at the schoolhouse, and that's what was happening. They were yelling at each other about who had the right to the water. There wasn't enough for everybody. Something had to be done. In the middle of the argument, one guy, there's always one guy, usually more than one guy or gal, it's often a guy, let's be real, who stands up in the middle of the thing and he says, "To hell with talking, every man to his rifle, his tent, and his cartridges." Now, what his tent had to do with it, I don't know. I think it's a Civil War reference, right? Like, go to your tent and get your rifle. Okay, we have just walked into a water meeting. They happen all across the West. Who here has ever been involved in something like that? Maybe not the pitchforks, maybe not the rifles, but this is a problem that has really consumed my career of 27 years. Thinking about trying to solve this really interesting problem. And that is that water is absolutely essential and also scarce. We need it for every activity, and we simply don't have enough of it in the right places in the American West. And how we solve that problem is a fascinating study in law, psychology, history, sociology, and that's what we're going to talk about in the next 30 minutes. But the way I want to approach it is to focus on Colorado. How did Colorado solve this problem? Well, we haven't. But how did we take steps towards it? And the way I like to look at it, and the approach that Tom Check and I took in our book, is to think of this as a kind of a play. We have a stage. This is the geology, the hydrogeology, the conditions, the weather, everything in our state. It's sitting there. It's been created. It's waiting for us to step onto the stage. We have the actors, which in our drama are the settlers coming from the east. And we have the script. We have the rule of law, the development of our water law concepts, and our conflict resolution techniques. Because after all, it's all about conflict resolution. I understand your course is about conflict resolution and creative ways to do that. That's what I've been doing for 27 years. That's what lawyers do, is we prevent and resolve conflict. And sometimes when you think about attorneys, you think, well, all they do is fight in court. Well, yes, it is an adversarial system, but the court is a brilliant mechanism for resolving disputes. We're in the business of dispute resolution. So when sociologists talk about conflict resolution, they have a hierarchy. I'm a little above my pay grade here, so forgive me if that's your major. But when there's a conflict, the first thing that humans resort to is raw power. I'm going to take your stuff because I'm stronger. Maybe there's a little bit of that in grabbing your gun out of your tent and heading upstream, right? We're going to resolve this. The second level is something called mediation by elders. The community comes around and decides the dispute. And the third is compensation. You have to pay me if you offend against me. The fourth is codified law, and the fifth is formal courts. After that, we get into stuff that's a little bit more aspirational, like international justice and restorative justice, things I know that you're pushing towards in this course. Where we're at today is moving from the very early days of raw power to the days of formal courts. resolving our disputes in the court is a good thing. It's much better than the raw power alternative. So the way that I'm going to do this is we're going to talk about a rule and 3 exceptions in Colorado water law. Okay, disclaimer, the next 17 minutes of this is the boring legal part. We're going to talk about a rule and 3 exceptions, but the way we're going to do it is I want you to picture or imagine that you've gone to a theater festival. There are 4 stages at the festival. There is a main stage, and then there are 3 alternate stages. So we're going to talk about the general rule of Colorado water law. It's important because you need to know what you're encountering, and you need to categorize the type of water rights that you encounter in Colorado in order to understand which type of law fits. Each different stage has its own geography and hydrology. It has its own set of rules, its own script, and it has different actors. And so that's why I think it's useful to organize it this way. Let's talk about the rule. But first, here's the stage. This is Colorado. And you can see it's separated into highlands on the west, the mountainous region in the center, and the plains on the east. On here, we have some groundwater aquifers. The large areas are deeper aquifers. The yellow areas are what we call alluvial aquifers. These are places where there were large ancient streams during the last ice age. And as the material, the water, flowed from the melting glaciers on the Rocky Mountains and out onto the plains, it carried lots and lots of rocks and sand and boulders of all sizes and distributed them in its path. So these are major prehistoric rivers. As time went on, we dried out. Those areas of cobble, of sand, of rock were covered by dirt, blown in by wind primarily, or carried down by the rivers themselves. And so we have a layer of dirt overlying these large areas of rocks and sand and gravel. Now, if we have a river, a surface river flowing on top of these areas, it's just as you would expect. Gravity pulls the water from the river down into these rocks, sand, and gravel and fills it up. The river stops flowing on the surface until all the yellow areas are full. When the yellow areas are full, the river can flow again because the underlying alluvium is full. So we have 7 major river systems in the state. Each one is governed by its own water court for our tributary system. But we are primarily in the first rule talking about these yellow areas, the alluvial aquifers and the streams that overlie them. Up here, we have the South Platte. Down here, we have the Arkansas, the Rio Grande, and so on. In order to understand how we got our primary system, the rule, the play that's unfolding on the main stage at the festival, you have to understand what we came with. When the actors arrived on our stage, I just showed you, they brought with them something called the riparian system of water law. I call this the duh system of water law. Here's why. What the riparian system says is if you own land that borders a river, you can use the river. All right, everyone all together. Duh, right? That's the duh system of water law. And so it's, I may be sort of dumbing it down, but it was first codified in the 5th century in the Justinian Code. The Romans actually made it a thing. And so what it says is that if you own the bank of the river, you have a right to use the river, including its water for your purposes, milling, etc. And so do your neighboring neighboring landowners who are on the river. If you don't own land on the river, out of luck. Don't get to use the water. That's the riparian system. It was developed in areas where there's lots and lots of water, very few shortages. But if there was a shortage in the riparian system, they would share and share alike. Everybody would take a little bit less. You know, the mill at point A would have to run a little bit slower. The mill at point B would have to run a little bit slower. They would all reduce their consumption proportionately. But again, key point, if somebody who wasn't on the river needed water, that was a big challenge for the riparian system. We arrived in the West. Act 1 in our play on the main stage is mining. That's the thing that put Colorado on the map. A gold rush in California in 1849 and one in Colorado in 1859 on Cherry Creek brought people in by the thousands. And in order to mine, to process and find the gold, you had to have water. This is a sluice box. We have civil engineering majors in here. Maybe they don't talk about this anymore, but at least you get the concept. You run water over corrugated bottom, and the gold is heavier, so it settles out in the corrugations, and the water runs and the dirt runs off. You go in, you collect your gold, you do it again. This guy's using a bucket, but if you were him and you were doing this all day, what would you want to do? Come on, civil engineers. Well, okay, if it was me, I'm just saying, I would connect this to the stream so that the water runs all the time, and all I got to do is turn a level, open a valve, right? Close a valve. Ingenuity, right? And so miners needed water. They needed lots of water. They needed it all the time. That's number one. So as miners arrived in the area, if you're the first miner and you set this up, great. You got your water, you can run your system. Second miner comes, that's okay. He's downstream of the first miner. There's still enough water usually. But then you get miners 2, 3, 4 through 50 on the same stream. It's June, it's July, it's August. Those of you who like to enjoy our mountains, what do the rivers look like in August and September? All of a sudden, there's not enough water. So the first guy is getting water. Everybody else is out of luck. So what does any self-respecting miner do when they don't have any water? This is dramatized for effect. They grab their rifle out of the tent and they head upstream, raw power. We're going to solve this, right? But then there's a community of them, of elders, let's say, and they get together and they say, okay, this is not going to work. We can give a little bit to everybody if we follow our riparian system. Everybody will have a trickle. Nobody can do anything. We're all done. It would be better if at least 1 or 2 miners could run, right? At least that's good for somebody, but who are going to be the 1 or 2? Well, the way it turns out, to cut the story short, is that the miners relied on their background, some of whom were in particular from Wales in a tin mining area, and also their experience in the California gold fields where these concepts were in play. They relied on that, and also a basic human instinct. This is the psychology part of the lecture. A basic human instinct called the queuing instinct. I guess it's a real thing. That if there's a problem, if there's a shortage or some sort of a backup, humans will instinctively get in line. And everybody knows if you're there first, you get to be at the front of the line, right? I mean, it's just a basic way of resolving things as a human. And so the other problem that the miners had was that the gold was not on the streams always. Sometimes it was, but often it was on the other hillside or across 2 hills and down a stretch. And so they started developing these elaborate ditches and wooden pipes, half pipes, and piping to carry the water away from the stream. Anybody see a problem? If anybody went back to their tent and got out their dusty volumes of the Justinian Code, can't you just see them standing in the mining camp saying, now, wait a minute, I'm next to the stream. And do you know what the rest of the miners said? We can't repeat it here. No, you're not. I was here first. And so one of the basic principles of the priority system We call it the system of prior appropriation. First in time, first in right. The first person to use the water has the best right to use it. So if there's a shortage, everybody else is shut off. Number one gets their water. All right, that's the principle. Now, in reality, there's number 1 through 500, and the stream conditions vary. So if you're number 499, if the stream conditions start to go down and we can't support 499, you're shut off. And so is 498 and 497 and so on and so forth until the top 300, let's say, all get their full amount. That's the prior appropriation system. If the stream comes back, those junior rights could get their amount. Key concept in that is that any party could use the water. You can pipe it away from the stream. You can have a water right and not even own land. Wow. The Colorado Supreme Court said that early on. And during a period, a very populist period in our political history, our Constitution also says that the water in the streams belongs to the people of the state of Colorado. And the right to put it to beneficial use shall never be denied. Pretty cool, huh? All of us in here have a right to use the waters of the state of Colorado. Now, before you start making a diversion on the Poudre River, talk to me after class. I don't have time to explain. It's kind of like the rule of water law. One of my longtime clients on the South Platte says, Colorado water law. You can, but you can't. That's his summary. Another genius thing was that there came an understanding that the rights were transferable. So if miner number 1 went bust and left, then there was an understanding that he could assign right number 1 to somebody else. How brilliant is that? Disappointing for number 2, but that's the way it came down, and it was eventually codified that way. So the rights can be sold and could be used in a different location for a different purpose, and so on. Act 2, same stage. Mining is starting to play out. A guy by the name of David Wall, who was mining, decided to plant a vegetable garden near Longmont. And he had a brilliant idea. He was a pretty astute businessman, actually, interesting guy in the 1880s. And he, probably interesting in other decades too, for that matter. He planted 2 acres of vegetables, sold them, and made a profit of $2,000. A lot of money at that time. A lot of money at that time, far more than he ever made mining. So the next boom was supplying the mining camps with food. And so this same system that had developed with regard to the mining moved into the agricultural areas. And the rules came to be that in order to establish this water right, which you were entitled to, you had to make a diversion, you had to apply it to a beneficial use, you couldn't waste, you couldn't speculate. So I can't make a big diversion and say, hey, all you new vegetable farmers, come to me. The law said, no, you can't do that. You have to have a use for it, and it has to be a beneficial use. And also came in to an idea that in terms of priority, if you started digging a ditch before someone else, you were in line ahead of them. That's a conditional right. As we started to divert this water and put it on farms, here's our ditch, here's our farm. Some of the water is consumed by the crops in evapotranspiration. Some of it is lost, and some of it percolates back into the aquifer I was telling you about. So agriculture became kind of a big water retiming project on the South Platte and the Arkansas. Thousands and thousands of farms, hundreds of thousands of acres. The water is taken out of the streams in the spring and early summer, put onto the fields, crops are grown, people are making livings, families are raised. Meanwhile, a percentage of that, usually about 30% at that time, went into this aquifer. And as it goes into the aquifer by gravity, it begins to want to return to the stream. Over time, it returns to the stream, and the rivers rise. So the rivers flow more as a result of human activity after 10 years, 20 years, 30 years, 50 years. And it's a different river. When explorers were in this area prior to development, driving cattle across here, they relied on the South Platte to water their cattle. And there's more than one story of them reaching the South Platte at Kersey and finding a dry stream bed. No water at all in the late summer and early winter. But now it runs year round because of this phenomenon. So it's possible to change the use of water rights in the prior appropriation system. So this is Act 3. Act 1, mining. We're still on the main stage. Act 1, mining. Act 2, agriculture. Lots and lots of valuable water rights developed because each one of them has a priority, which is value, because they can sell that to someone else. This is Act 3. We'll call this development. Farms start to recede, and we're growing more and more houses, subdivisions, golf courses. We need more water for industry. So the people who are building the houses, the municipalities, supplied by the municipalities, begin buying the senior water rights. If you're going to have a city and you're going to build a nice new subdivision with lots of green lawns, you cannot be number 499. Those people have to drink, number one. And if they don't get their water to water their lawns, almost as bad, right? So what do? You go by number 1 and you change it so that you can use it for your purposes. In this case, our development is represented by a factory. How do we do that? We allow you to make a new use in that same priority if you can do it without injuring any other water rights. So, and how would you injure other water rights? Well, historically, there was all this water that was going back into the aquifer, which supplied the river, which made it possible for the next water right down the river to divert. If you take this away, that person is not going to have any water. And we already said, what happens when you don't have any water? Well, we're a little further down the dispute resolution scale now, but you go to court. You sue somebody now, right? So our rule is you can change it and do a different use if everything looks the same as when you were farming. So if you look at this quickly, we can see we're diverting the same amount, we're consuming the same amount, and we're intentionally returning the same amount to the river to make it look just like we were farming. It's very precise in terms of the timing and the amount. If we do all that stuff and the water court gives us a blessing in the form of a decree, a court order, now we can use number 1 to supply our city. And that happens over and over and over. Condition of this is that if we're using it for our city, we can't farm with it too. The farm has to dry up. And I know many of you are familiar with those kind of stories. There are some change in use terms that are in the water court decrees that some of you might be interested in if you pull up this presentation later. Final act on stage 1, key concept, augmentation plans. Okay, I told you about the alluvial aquifer. In about the 30s, let's say, we started realizing, we as Coloradans started realizing, and the technology was available to pull water from these alluvial aquifers and to irrigate with it. Another boom in agriculture, installation of center pivots, electrical pumps, and our water law system was not ready to deal with that. Maybe some of you already see the collision course we're on when this starts to happen. Let me give you a sense of the magnitude of this. So you remember the yellow area that was the alluvial aquifer filled with water that the stream was depending on to run. This is a diagram of wells in the South Platte River Basin. Does it look familiar? Those well drillers knew what they're doing, right? It exactly mimics the alluvial aquifer and completely covers it. So if I suddenly flip a switch and by 1970, 1980, all of these wells are sucking water out of that alluvial aquifer, what do you think happens to the stream? The stream starts to go down. It's not supported by that aquifer anymore. Water starts to reduce. And those guys with the original ditches, guys and gals with the original ditches say, where's our water? This was our crisis around 2002. And a big, after many years of litigation, we came up with a concept or implemented a concept that we had actually had in the law of something called an augmentation plan. An augmentation plan allows the wells to pump, but only if they put water into the river to replace what they're doing. And I skipped a step in the explanation. Maybe some of you have it already. Why do the wells have to replace for the benefit of the ditches? What's our system on stage one? Which one is senior? Ditches or wells? Ditches in general, right? So the ditch owners are like, hey, we're senior. You got to replace us. You can run the wells, but in order to do so, you have to put water into the river to match what you're taking out by sucking it out of the aquifer. So how do the well plans do that? Well, in part, ironically, by doing this. By buying senior ditch rights, changing their use, and committing them to offset well depletions. Another way is we develop additional storage and recharge plans to take advantage of the large flows in the spring. So that's stage one. And I have a summary here of the characteristics of that in your handout. That is the stage one, that's the rule. So if we encounter water anywhere in Colorado, a client, a project, whatever it is, the first thing I want you to pop into your head is, this is a tributary water right. What does it mean that it's a tributary water right? It means it has to divert in priority. If it's a well, where's the augmentation plan? If it's a ditch right, where's the decree that the water court entered? What is its priority? Where does it stand in the pecking order? Those are the questions you're going to ask about these kinds of water rights. 3 exceptions. The first, this is on alternate stage 1 here, let's say. This is a confined aquifer. These are aquifers that are not alluvial aquifers. They were laid down during the advance and retreat of inland seas in geologic time, many eons ago. Water was trapped in there. Highly simplified explanation. And confining layers were deposited by wind or other processes. So we have fresh water trapped in this confined aquifer. It's under pressure due to gravity. And so that these are artesian wells. If I put a well in here, because of the weight of all this column of water pushing down, it'll push water right out the top. That's what we mean by an artesian well. When the Brown Palace Hotel was first installed in Denver, its elevators were run by a well into the Denver basin aquifers. So this is the stage. This is the first alternate stage. We need a different way of doing the law with this because it's not connected to the streams. Do you see that? It's separated from the stream. And if I pump water out of here, in the cleanest possible case, it has no impact whatsoever on the stream. That's different than our main stage. Here are some non-tributary aquifers. The biggest one is right here. It's the Denver Basin set of aquifers. I don't have time to describe the geology very well, but they're kind of a pancake, layers of pancakes, aquifers in between each layer, and water available if you're willing to drill down deep enough. So question for this set of actors, how are we going to distribute that water? Answer, we're going to look to concepts of mining law. We're going to distribute it based on overlying land ownership. Sound familiar? If you own the land over a portion of this type of aquifer, you can put a well into it. And because it's non-renewable, we have to decide how long are we going to make it last. The General Assembly says 100 years. So if you own land over these areas, you can put a well into it, pump it out, and exhaust it in 100 years. Theoretically, the amount that's underneath your land. Now, in reality, there aren't walls between the different property lines. You understand that, right? But they're doing that. That is the system of administration. And so in this case, these water rights can also be quantified, sold. The significance of these is that South Denver, in particular, and El Paso County have a heavy reliance on these wells, which have dropped precipitously over the last couple of decades. And they're a temporary source of supply. They're going to run out. We're mining them. That's the first alternate, the first exception. Why is it an exception? No priority system here. Nobody's first, nobody's second, nobody's last. You own it, you own it. Second, designated groundwater. We found that some areas of the state do not have flowing streams, but they do have big alluvial aquifers, and you can put wells in them. That's different. If you pump a well in these areas, it takes sometimes up to several thousand years to affect the flowing stream. Doesn't really make sense to regulate it, to have an augmentation plan that requires the replacement of small amounts of water 2,000 years from now. I mean, we're pretty crazy in water court, but not that crazy. So the General Assembly, based on the fact that economies were already established in these areas and also in the Ogallala Aquifer, which is another beast of its own here, but not related to surface water, not directly connected to surface water. In these areas, lots of wells, not much connection to surface water. By a legislative and administrative process, they can be declared kind of their own fiefdom, their own carving out from the priority system. They're not governed by our traditional priority system, much to the chagrin of priority system hardcore types, because it was really kind of an accommodation. Are they connected to the streams? Some of them, yes, but not enough. It's a question of how much. And the term that they use is a Latin one, de minimis. It's a de minimis connection to the stream. So these are governed by a special body set up by the General Assembly, which they like to do, something called the Colorado Groundwater Commission, which is appointed by the governor. And there are permits that people have in these basins. If there's a dispute between wells, if the aquifer gets low, because these aquifers are also mined at times, although they are replenishable. If there's a dispute, the General Assembly told us to use something called the modified prior appropriation system, which has not been fully tested, but it means something along the lines of you can hurt the other rights, but not too much. So you can see there's lots of job security for people like me in that. Third exemption, it's our wild card. This is the third stage, kind of the third stage being in our imaginary theater festival here. Third exception to our rule of tributariness. Exempt wells. In another unusual stroke of common sense, the General Assembly realized that it doesn't make sense for individual homeowners to adjudicate a plan of augmentation and replace tiny amounts of water so they can flush their toilet, and so it created a category of wells that are small, are limited to either in-house uses or stock watering or sanitary use within a commercial facility. Some of them can have irrigate up to 1 acre of lawn and garden. So very small uses. And they said, okay, we're not gonna, if you stay within these small uses, you can have your well pump permit, you can pump your well, and we'll act like it doesn't exist for the purposes of the priority system. So it's kind of a wild card. So this one you encounter quite a bit, maybe in your personal life or in other places where You know, if you're gonna build a house at Red Feather, let's say, you're gonna get an exempt well. Or a lot of real estate transactions I see, you know, we have this exempt well, what does it mean? Or more commonly, we have an exempt well and we want to divide our property. Can we get another exempt well? No. But questions like that proliferate. So it's exempt from the priority system in the sense that it's not required to replace, it's not administered in priority, doesn't have anything. It's available all over the state. As a proper lawyer, I'd be remiss if I didn't tell you that the exemption that exempt wells have is only a presumption. We like those things in the law. So what it says is, if you meet these requirements, we'll presume you're not hurting anyone and you're exempt from the priority system. But what that means is, you know, in the law, in the context of a court case, it's possible to overcome that presumption with evidence to say, no, there's 5,000 tributary wells in Red Feather and it's affecting my water right. You know, you could say that. That's theoretically possible. So, all right, that's our rule and 3 exceptions, our main stage and 3 alternate stages. The rule is all waters are tributary. We talked about what that means. That's our first in time, first in right. The exceptions are non-tributary groundwater, the deep aquifers that are divided by overlying land ownership, designated groundwater, special areas on the eastern plains where the economy is all about groundwater and they're a long ways from any stream, and exempt wells, which are small capacity wells. So I'm a little bit over. Would you like to go to questions or should we hit the dispute resolution stuff? Would you?
Yeah, let's do a little bit of that if you can.
Okay. Yeah. I was hoping to be able to get to this point, and I saw that you were doing the dispute resolution issue and the conflict resolution, and I thought about, okay, I've been doing this a long time. I've been in a lot of these meetings for better or for worse, some successfully resolved, some not. So we're going to return to the Eaton Schoolhouse. Well, we left off, the guy had just stood up and yelled, "Every man to his tent, his rifle, and his cartridges." Well, the story is he was subdued. A discussion continued. And Benjamin Eaton stood up and he said, "I have an idea. How about when things get low, we'll just share and share alike?" How do you think that was responded? The report, the quote that we have says that the Union colony delegates hurled, quote, "hot and unseemly language" at Benjamin Eaton. So that didn't go so well. They continued talking. They didn't resolve it that day, but there was no fight. There was no violence. They left. And it initiated a discussion that led to the development of our water law I just described, the main stage, tributary water law, the priority system, how you establish a water right and all of that. It just so happened that they somehow, you know, got apart without fighting that day. And then shortly after that, it rained, which often happens. Sometimes these things happen, and it was not as big of an issue, but the discussion continued and the first adjudication acts were actually implemented in several years later by one of our early governors, Benjamin Eaton. So that's how that story ended. I was thinking about all the meetings like that I've been in and what really worked for me. So this is kind of like the experience chalk talk part of this, that this is just what works for me. And I've studied dispute resolution some. I've been a mediator and taken those courses, but this is really just distilled down to what really works, not the theoretical stuff, what I do and what's worked for me. And it doesn't always work, but this is the best I got. So 5 steps if you're going into a contentious meeting between, on any issue. We're talking about water here. Number 1, establish the rules and the environment of the meeting. This is critical. Hopefully you have some kind of a designation as the coordinator or the facilitator of the meeting. If you do, that makes it a lot easier. But you really got to step into that. You want to be friendly, firm, and fair is the way I would characterize it. Don't go in there serious. Smile if you can. Try to lighten things up. But at the first opportunity, also demonstrate that you're going to be firm and you're going to be fair, because people will immediately begin to test the boundaries. When you go into something like that, if I was going into the Eaton schoolhouse, that's the first thing. Even if I didn't feel like it, I would act like I knew what I was doing and I was going to control this meeting and I wasn't concerned. And really try to put on that. And then I would look around and look for allies and potential problems. I'm not doing that right now, so don't get nervous. But I would look around and I would say, okay, you can tell there's in any meeting, there's a number of people that are really pretty fair-minded. Some of them are afraid to speak up. Another common type is there's somebody who is actually sort of in charge, but is not speaking up. He's letting everybody else argue first or whatever. So look around for those people. Also look for people that seem agitated and otherwise sort of psychologically unwell. So you can be ready to respond to that. Step 2, I found it critical to allow opening statements. People need to say what they're going to say. And you just got to set up the rules that, like, expressing your anger is fine as long as it's done in a way that's not abusive. Get as angry as you want, and if you try to our temptation as humans is, if people around us start arguing, or some of us anyway, we want to interrupt. We want to say, well, now wait a minute. No, don't you see, just let them go. Let them go for a while until they stop. That's the first step. Let both sides do that. Expressing anger in and of itself isn't really that helpful, the studies have shown. But if it's followed by some sort of reflection or reframing, it is. So let them say what they're going to say, and then you're coming in and reflecting back what they have said. So let me give you an example. 2 farmers next to each other, one's irrigation water is flooding the other one. The guy who's getting flooded is just absolutely sure that the guy's doing it on purpose. And he's probably part of some conspiracy or something too, I mean, he's just completely gone with it. As you come in, you allow these guys to say what they're going to say. The guy who is being flooded might say, exactly that. I think you're doing this to me on purpose, and I can't farm, I can't get my equipment in there, and so on and so forth. At the end of that, I might say something like, so really the problem with the flooding is you can't get your tractor through there. That's reflecting back what somebody said. And it's also a little bit of reframing, saying, okay, I didn't really hear all that stuff about how he's a conspiracy. He's part of a conspiracy. What I heard is you can't get your tractor through there, And so most problems, most solutions in this kind of a situation come through reframing. What is reframing? Reframing is seeing the same set of facts in a different way. And that is almost always, in thinking about it, that is almost always how these things are resolved. So we want to start laying the foundation for that reframing by reflecting back what they're saying. Next step, this is the meat of it. This is the critical part. Identify interests and issues. For those of you that have studied dispute resolution, I'm just firmly believe in the interest-based approach that has really been successful for me. An interest is a goal or a positive outcome sought. It's different than the issue, the way that I see it. And I just made this stuff up. If it happens to coincide with somebody else's theory, I'm sorry. The issue is, to me, the issue is why you're there. He's flooding my field, right? The interest can be, it can be related to that or even unrelated. Example, in our example, the downstream farmer's interest, maybe he says something like, all I really want to do is get my tractor in there and cultivate every 2 weeks. That's all I really need to do, deeper level. I'm just trying to raise a crop and support my family, Another interest that's related that you can capitalize on that people often have is the desire to be fair. I have a desire nobody really wants to be seen as unfair, right? The desire to be seen as fair. Another one, an interest that people have that you can sort of suss out is to save face. That's a common one in negotiations. I really don't want to do this, but I can't be seen in this way. That's important. That's an interest. They have an interest in appearing a certain way. Those things are important. So we're diving in and we're trying to find the interests. What are the interests of the parties? Because a lot of times we can find a solution that honors both interests and resolves the issue. So key points, red and green, interests are more important than issues. If we focus on the issue, we're only on the first level. If we look for the interest of both parties, we're making progress. And the other thing, absolutely critical, interests are not individuals. I can't tell you the number of times I have come into a situation with parties just livid at one another. The moment that we around the table are working on a problem together, that's it, we've got it. You see what I mean? When they come in, they are the issue. They are, but the big exercise a lot of times in this dispute resolution is getting that issue away, getting it out, moving people from their amygdala to their prefrontal cortex, right? Another psychology bonus. Like getting that problem out away from us. And sometimes you can do that by building camaraderie. Like it's crazy. So in our situation, they came in hating one another. And it's not that far-fetched that the guy who was flooding the other guy would say, I'm just trying to make a living too. That's a breakthrough right there. They're both trying to make a living. And we have something to come around, So those are the kind of things where you try to pull out the individuals. You want the individuals to feel powerful and reasonable and to apply their power and reason to the issue. So important thing while we're doing this, you're summarizing progress. That's your role in this. You're reflecting back what they're saying. So if you could cultivate every 2 weeks, that would be okay. Yeah, I guess so. I guess that'd be all right. And then, the other guy says, well, maybe we could time the irrigation such that it doesn't affect your cultivation. Yeah, no kidding. And then so the process summary is, okay, what I've just heard is that the main thing, B is trying to do is to cultivate. And A, are you saying that you could do it every other week, or whatever like that? And so you're summarizing it back to them and saying, here's the progress we've made, and I tend to use a lot of we's in the conversation. Some people don't like that, but I find it helpful. And then part of your job in this is to record the outcome as well, to say, okay, great. So what we've decided here is that, you're going to run your water on these days and so that he can cultivate on these days. And we're going to take these other steps. And I'm going to send you both an email. I'm going to put this into a memo or something like that. And it may not be the nice, neat resolution like I needed for my example. It may be a really wicked problem that's just going in steps, but you could, whatever steps you made, we heard from so-and-so that this was their primary interest. And from the other person that, there may be ways to accommodate that and so on. So summarize. So this is what has worked for me over the years. And I hope you never find yourself in the Eaton schoolhouse. That sounded a little dangerous, but I do hope you have a chance to apply some of these principles, and maybe some light bulbs will go off with this Colorado water law too. So that's all the time I have. I have a couple minutes for questions if anybody wants to throw them up.
Questions? I think it's resolved.
Exactly, right, like, sure, yeah.
So around Wellington, people say,
Yeah.
oh, I have a coffin well.
Yes,
And What is that about?
Oh, that's a great question, and it brings up a fun story. So back in the late 1800s, I think I'm shooting from the hip here. It was the 1800s or early 1900s. There was a district court judge in Greeley by the last name Coffin. And he was the water judge. At that time, he was resolving the water issues, and people came in to adjudicate wells. And the claim that they made was this well is not connected to the streams. It's many miles from a stream. It doesn't affect the flow in a stream when I pump it. And based on, well, even the engineering at that time would have told Judge Coffin he was wrong, but he said, you know what, you're right. And he entered decrees that said, this well is not connected to the stream. It has an exemption from the priority system. And this is the power, this is the point I wanted to make was that, excited about this. The power in our court system, once a water right is decreed, that decree is right, even if it's wrong, forever. So the coffin wells, if somebody come in and they have a coffin well and they say, what does this mean? I said, well, you can continue doing what you're doing and irrigating like the decree says forever, and you don't need an augmentation plan. You're fine. The caveat, of course, you can, but you can't. You can't change that well or use it for any other purpose, or they will re-examine the status of the well. So that's what those are.
Other questions?
Other questions?
I have a question online.
Okay.
Question regarding, oh, here's one of them. Were changes in water right uses and plans for augmentation early concepts in water law, or did those concepts come about later?
They came about in 1969 in the 1969 Water Rights Determination and Administration Act. And they were in response to a study of the South Platte and Arkansas systems, assessing the impact of wells in the basins. So they were very early and, pretty intelligent responses to what they were seeing with the well problem. The interesting thing is it was passed in 1969 and was not fully implemented until 2002. So we had a long period of partial implementation.
Okay.
Here in Fort Collins, we have 4 ditches that run across town off the north side of the river, one of which passes right through campus.
Mhm.
What rights do the ditch company have regarding those ditches versus the landowners on the sides?
Right, yeah, good question. So the right, first of all, is defined by any written easement that's recorded. That's the first thing. But typically easements that old are not recorded. And so it is the right to use, maintain, repair, and replace as necessary. So it's a flexible concept, but it typically extends to access to both sides of the ditch, the right to tear it up, replace it, the cut down trees that are impeding the flow. We have a lot of disputes now about cutting down big cottonwoods on the ditches. Landowners don't like that. They come out variously. They're often settled. The most recent one was in Loveland, and it was settled. Certain trees were marked for destruction and others were not. But so the easement rights that a ditch owner enjoys are broad. They're based on necessity and historical use. So
Public access on ditch banks?
no, they are a private easement. So
If
yeah,
the ditch breaks and floods you?
there is liability there. Yeah. Mhm. Depending on the circumstances, it would be a typical negligence type case.
Okay, well, I think we're out of time, but let's thank Andy again.
I'll be around
Stick
for.
around for a couple minutes.